Ever pondered the intricacies of housing repossession in Quebec? It's a process that often ensues due to various circumstances, often involving a landlord wishing to reclaim their property for personal use or that of a close relative. But what exactly is repossession? Repossession is a legal process where a landlord reclaims their rental property for personal use or for a close family member. It's not a simple process of eviction, but a structured process that must follow the Quebec rental laws meticulously. However, there are situations where repossession is not allowed. For instance, if a low-income senior who has occupied the rental property for more than 10 years resides in the unit, the landlord cannot repossess. The law protects those who are most vulnerable, ensuring they have a safe and stable place to live. Now, if repossession is permissible, the landlord must provide a formal notice to the tenant. This notice must be given 6 months in advance for a lease of less than 12 months, and 1 year in advance for a lease of 12 months or more. It's important to note that this notice must be sent by registered mail or be delivered in person. So what can a tenant do upon receiving a repossession notice? Well, the tenant has 1 month to respond. They may accept, negotiate a delay, or refuse the repossession. If they do not respond within a month, the law considers it as an acceptance of the repossession. If the tenant refuses, what can the landlord do? The landlord can apply to the Tribunal Administratif du Logement, TAL, for a hearing. The TAL is the governing body for rental housing disputes in Quebec. During the TAL hearing, both parties present their case. The tribunal will then make a decision based on the evidence provided. It's important to prepare for this hearing, as it will significantly influence the outcome of the repossession. After the hearing, if the repossession goes ahead, the tenant must leave by the date set by the TAL. If the repossession does not go ahead, the tenant can continue to live in the property under the existing lease agreement. However, if a landlord acts in bad faith, for example, if they do not use the property for the stated purpose within 6 months of repossession, the tenant may be entitled to damages. It's crucial for both parties to act in good faith throughout the process. In conclusion, the repossession of rental housing in Quebec is a complex process that requires careful navigation of the legal landscape. It's essential for both landlords and tenants to understand their rights and responsibilities and to act in good faith throughout the process. Remember, the law is there to protect both parties, ensuring a fair and equitable housing market for all.